Hello friends, my name is Samriti. I am a faculty for Strive Edge IAS and I will be taking the PT 365 for polity. So let's begin. Let's start with the issues related to the constitution. First of all, the basic structure doctrine. Why is it in news? Because the case 1 and the Bharti judgment has completed 50 years. And that was the case, that was a landmark judgment which gave birth to a lot of doctrines. So first of all, about the case, basically the case dealt with petition against the compulsory acquisition of land in Kerala. The land reforms that was happening at that time. So it was based on that. And also the case was very important because it had the largest bench ever. Okay, of 13 judges. So this particular, wherein there is a question of constitutionality happening, that is called a constitutional bench. And that was the largest. Okay, so what are the key outcomes of the judgment? एक तो सबसे पहले it came up with the basic structure doctrine. Okay, so what is this basic structure that we're talking about? So basic structure is that there are certain fundamental features of the constitution that cannot be amended or abrogated by the parliament. Now we know that the parliament can amend the constitution according to the article 368. Okay, so we know that our constitution is not rigid, it is susceptible to change, and for that we have the article 368. But there are some parts of the constitution that cannot be changed, and that part is called the basic structure. You can change everything, but you cannot have a dent in the fabric of the basic structure of the constitution. Now what is this basic structure? Is it defined anywhere? No, there is no mention of basic structure in the constitution. Okay, it is an established rule, okay, with the case 1 and the Bharti case in 1973. So it is not mentioned anywhere, and nor is it defined by the court itself. Okay, there are some principles that are part of the basic structure which have been evolving ever since, but there is no particular definition, there is no particular exhaustible list wherein that you can say ki only this part of the constitution is basic structure, because we know that the society is constantly evolving and the needs of the society is are evolving. So with respect to that, it is an inexhaustible list. Okay, so some of the principles that are there in the constitution which are called as the basic structure. So you can amend everything, but you cannot abrogate or you cannot arbitrarily amend these particular things, jaise sovereignty of India, okay, and essential features like the freedoms, fundamental rights. You can amend these, okay, but the basic, the core of the constitution, that cannot be amended. Mandate to build a welfare state. Okay, tomorrow you cannot get up and say that we are not a welfare state anymore. Okay, supremacy of the constitution. We know that constitution is greater than parliament. Okay, so we have supremacy of the constitution. Republican and democratic form of government. Secular and federal character of the constitution. Separation of powers, unity and integrity, judicial review. Okay, balance between the FRs and the DPSPs. So these are with the help of some of the cases that we have developed this particular list. Okay, so what is the significance of this doctrine? So for that, you can use your existing knowledge. What will it do? It will have the check on power, because parliament is the one who's going to amend. And what if the parliament does things arbitrarily? Okay, what if it goes haywire? So for that, the constitution will be checking. So with the basic structure. Okay, and it will ensure that constitution remains a living document. What do you mean by living document? Like I said, the society is constantly evolving, and there are a lot of changes happening around us, so we have to be responsive to that. You cannot have a rigid document, you cannot have a document that cannot be changed with time. That will be a dead document. Okay, but you need that kind of change, but you should also preserve its fundamental values and principles. Okay, what else is the significance is that it laid down several principles that have become the bedrock of the constitutional law in India. For example, here we saw, okay, it talked about secular, federal, separation of powers, checks and balances, unity and integrity. So the basic structure has laid this kind of foundation in India. Okay, and it ensures the federal structure, and it shapes the judiciary's approach. Now, when you see, there are a lot of cases happening and you don't know. For example, let's talk in terms of judiciary. Okay, so if you want to give a particular kind of ruling and you don't know how to, you don't have any reference, but this can be your reference, the basic structure can be the reference. Okay, so you know that you cannot move beyond that. Okay, you have to stick on to the basic structure. So how was this particular thing evolved? Like what was the process of its evolution? So सबसे पहले it was the A.K. Gopalan case, okay, in the 1950s, and the Shankari Prasad case in 1951, and the Sajjan Singh case in 1965. So all these things, all these cases, they had this kind of notion wherein the parliament could amend any part of the constitution, including the fundamental rights. So the power of the parliament was greater than the FRs. Okay. Then came the Golaknath case in 1967. Now, this particular case said that the FRs cannot be amended by the parliament. So, somehow, here FRs became too greater than the parliament. Okay. After that, so in response to this particular case, the then government did these amendments, the 25th Amendment and the 24th Amendment. Okay, so here in the Golaknath case, it was said that the 368 did not give power to the parliament to amend the constitution. Okay, so in response to that, what did the 24th constitutional amendment say? That the amendment is not a law under Article 13. So parliament can amend it. Okay, and in the 25th amendment, it took precedence of DPSPs over FRs. So whatever laws that were making, the parliament was making. So here again you can see that the parliament is greater than FRs. The FR is for individual rights, and DPSPs are taken collectively. To enforce DPSPs, you need to make some laws. So parliament is making laws. So here parliament's role was considered higher as that of the fundamental rights. This happened in 1971. Okay, and then in the 1973, finally, Keswananda Bharati case happened. So what did this case say again? It upheld the 24th constitutional amendment, which said that the parliament can amend, because इससे पहले क्या कह रहे थे कि the parliament cannot, fundamental rights cannot be amended by the parliament. So it said कि हाँ ठीक है, कर सकते हो तुम लोग. Okay, you can amend the FRs, but okay, it should be subject to the basic structure. So you cannot take away this particular part. Okay? Let's go to the next one. Here again, it talks about the independence of district judiciary as a basic structure. Who has said that? Supreme Court. Okay, in All India Judges Association versus the Union of India case, it has said that the district judiciary's independence is part of the basic structure. So this also can be added. So you can see the list is ever increasing. Okay. What else did the case talk about? It talked about integration in terms of pay, pension, okay, separation of powers from staff of legislative and executive wings. Okay, so the judiciary staff should be treated separately and unified judiciary. Okay, so the service conditions of judges for similar posts are equivalent across states. So you can see that district judiciary, even the names for district judiciary, it can be different from place to place. There is no particular one unified nomenclature for that. Okay, so they differ slightly in terms of names, in terms of pay, maybe the service conditions. So the case also talked about having a unified, a standard, a benchmark for all the district judiciaries. Okay, you can see the hierarchy over here. Okay, this is for you to go through and understand the district and sessions judges, who comes after, who comes under who. Okay, so basically appointment, posting and promotion of district judges are made by the governor in consultation with the High Court. So the district judiciary is under High Court of that particular state. Okay. Next we have the abrogation of Article 370. So this particular 370 during 2019, the Constitution Order of 2019. Okay, it was an ordinance. Okay, so some people, some interest groups had doubts about it. So they had again approached this Supreme Court with the question of constitutionality of this particular order. Okay, and in response to that, the Constitution Bench of the Supreme Court, it upheld the validity. Okay, it said that it was constitutional, the abrogation of Article 370. So there were two orders at that time. Okay, एक तो ये order हुआ था, and then Parliament had enacted this particular Jammu and Kashmir Reorganization Act, which had bifurcated the state into two union territories. Okay, now we are seeing the question of Ladakh also. Ladakh, that was the union, now which is the union territory. So they are also having some kind of demands. Okay, so एक तो था the order which had said that the provisions of Indian Constitution are applicable in the state as well, which were not in the earlier case, and the Jammu and Kashmir Reorganization Act, which bifurcated the state. Okay, so what did the judgment say? It held that the Article 370 was a temporary transitional provision. Okay, and that the J&K did not retain element of sovereignty after it acceded to India. So what had happened? There was an instrument of accession. Okay, Maharaj Hari Singh at that time, okay, he had agreed to accede his state to the dominion of India. But तब तक ऐसे हुआ था that it was a little bit late, and the tribal groups of some part of the neighboring countries, they came inside, and then there was a lot of havoc happening. All of that happened, and so now also we have this bone of contention between the neighbors, okay, with respect to Gilgit, Baltistan, and all of these things. Okay, so at that time what had happened, that because there was so much chaos going around, so there were some kind of temporary provisions that were taken, and article 370 was placed in the part 11 for temporary and transitional positions. Okay, so what did the article 370 say? That except for defense, foreign affairs, finance, and communications, Parliament needed the state government's concurrence for applying all other laws. Okay. Now, otherwise, if you see in the rest of India, we see that we are a unitarily tilted country, is it not? Our center-state relations, if you see, the center is more powerful than the state, and it can unitarily take some decisions. But in the Jammu and Kashmir's case, it was that except for these particular, which are the defense, foreign affairs, finance, and communications, except for these particular 4 subjects, बाकी सबके लिए Parliament needed the state's concurrence. Okay, so that was that article 360. And there was another article, article 35A, okay, which gave power to the J&K Assembly to define permanent residents of the state, their special rights and privileges. So this particular thing was also there. So not some rights were there, okay, for the permanent resident, like somebody who's not a resident of Kashmir couldn't just go and buy land over there. So all these things were there in the beginning. Like we don't have, like the US has 2 citizenships. They are the citizens of their state and the country, but we have just single citizenship. Okay, we are the citizens of India, but here there was this concept of permanent residence. Okay, so बाकी states में ऐसा कुछ नहीं है, but this particular temporary provisions were there. ठीक है, and the Parliament took this decision, like the ordinance was passed under Article 3. What does the Article 3 say? The Parliament may by law form new states, alter areas, boundaries, or names of existing states. Okay, and this shall be introduced on the recommendation of the President. And if it affects the area, boundaries, or name of any particular state, President must refer the bill to that state for its views. Okay, so that was about it. Next, we have the National Capital Territory of Delhi Amendment Act. Okay, so why is it in news? Because it has received assent of the President. So what are the key highlights? एक तो सबसे पहले the Civil Services Authority, National Capital Civil Services Authority. तो एक ये नया statutory authority बन गया है, okay, to make recommendations to the Lieutenant Governor. Okay, who is the Lieutenant Governor? He is the administrator of the Union Territory. Okay, with the state government, there's this administrator also. And तो जो भी ट्रांसफ़र, पोस्टिंग, विजिलेंस एंड अदर इंसिडेंट मैटर्स ऑफ द सिविल सर्वेंट्स जो भी है उस पर्टिकुलर यूनियन टेरिटरी, मतलब दिल्ली के, तो हु विल टेक ऑल दोज डिसीजंस? द लेफ्टिनेंट गवर्नर विल टेक अकॉर्डिंगली. हाँ, लेकिन किसके कहने पे? बेस्ड ऑन द रिकमेंडेशंस ऑफ दिस पर्टिकुलर अथॉरिटी. ओके, एंड द डिसीजंस विल बी टेकन बाय मेजॉरिटी. एंड इनका अपॉइंटमेंट जो है, ये अथॉरिटी का अपॉइंटमेंट कौन करेगा? द सेंट्रल गवर्नमेंट, बोथ द प्रिंसिपल सेक्रेटरी एंड द चीफ सेक्रेटरी ऑफ दैट अथॉरिटी. ओके एक तो ये किया उस एक्ट ने. नेक्स्ट व्हाट डिड इट डू? पावर्स ऑफ एलजी. ओके where on what areas can the lieutenant governor act on his discretion? What do you mean by discretion? Discretion is with your own, matlab there are discretionary powers, right? Governor has discretionary powers, the president has discretionary powers, because otherwise they have to depend on the aid and advice of the council of ministers. But यहाँ पे they can use their own discretion, their own will. Okay. So matters outside the legislative competence of the Delhi Legislative Assembly, but which have been delegated to the LG. So where all can he use his discretion? In this particular part. And secondly, where he or she is required by law to act in his discretion. ठीक है. एक तो जो लेजिस्लेटिव असेंबली की कंपिटेंस के बाहर जो है वहाँ पे ही कैन यूज हिज डिस्क्रेशन, प्लस वेयर ही इज रिक्वायर्ड टू यूज हिज डिस्क्रेशन. ठीक है. व्हाट एल्स डज द Act do? It gives primacy to the lieutenant governor. ठीक है. तो what do you mean by that? It expands discretionary role. अभी तुमने देखा यहाँ पे. Okay, it is expanding. It is giving him more powers. यहाँ पर भी, NCCSA में भी. Okay, जैसे सपोज किसी ने जो अथॉरिटी था यहाँ पे, सिविल सर्विसेज अथॉरिटी जो था, दे रिकमेंड सम नेम और इन मैटर्स ऑफ ट्रांसफर्स, पोस्टिंग, विजिलेंस में दे गिव सम रिकमेंडेशंस एंड द lieutenant governor doesn't like it or something. Okay, then he can return it for reconsideration. And again, if the same decision is sent, क्या होगा? The LG's decision will be final in the case of difference of opinion. Okay, so you can see ज़्यादा डिस्क्रेशनरी पावर मिल गया है. ओके देन और क्या करता है ये वाला एक्ट? विच नंबर वॉज दैट नाउ? 4th. सॉरी. Okay, disposal of matters by ministers. Now there are certain matters which must be submitted to the governor by the ministers. Okay, for his or her opinion prior to issue of any order. मतलब suppose the state government wants to issue some kind of order, लेकिन for that to happen, prior वो order pass करने से पहले they have to take the, मतलब जो भी matter है they have to take it to the governor so that he can give his क्या कहते हैं, डिस्क्रेशनरी, मतलब ओपिनियंस ऑन दैट. ओके, एंड ऐसे सर्टन मैटर्स है. कौन से है? एक तो है पीस एंड ट्रैंक्विलिटी ऑफ दिल्ली, रिलेशंस बिटवीन द दिल्ली गवर्नमेंट एंड द सेंट्रल गवर्नमेंट, सुप्रीम कोर्ट और अदर स्टेट गवर्नमेंट्स, समनिंग, प्रोपगेशन and dissolution of the legislative assembly, and matters on which LG is to give an order in his sole discretion. Okay. Now you see the governance model of Delhi NCT. So under the State Reorganization Act of 1956, Delhi was classified as a union territory under Article 239 of the Constitution. So what does the article state? It states that the UTs are directly governed by the president or an administrator. तो अभी हमारे केस में administrator कौन है? The LG, appointed by the president. Okay, and it has a special status on the recommendation of the S. Balakrishnan committee. ठीक है. एक 69 कॉन्स्टिट्यूशनल अमेंडमेंट हुआ जहाँ पे 239 AA आर्टिकल वॉज एडेड विच मेड दिल्ली अ यूटी विथ अ लेजिस्लेचर. ओके, सो the lieutenant governor is designated as the administrator of Delhi, operating with the aid and advice of the council of ministers. तो जैसे स्टेट में होता है, that kind of thing happened with the help of article 239 AA, wherein the lieutenant governor acts in the role of the governor. Okay, and ये अपना state government है ही. Okay, the union territory government. ठीक है. So the Delhi Legislative Assembly, that is the UT government, has the power to legislate over subjects in the state list and the concurrent list, except for पुलिस, पब्लिक ऑर्डर एंड लैंड. ये अदरवाइज स्टेट लिस्ट वाले सब्जेक्ट है ना. बाकी कोई अगर स्टेट हो तो उनका लॉ एंड ऑर्डर, उनके लैंड्स वगैरह स्टेट लिस्ट में होते हैं. दे कैन रूल ओवर इट. बट दिल्ली के केस में, बिकॉज दिल्ली इज अ स्पेशल केस, इट इज़ डिफरेंट. ऑल्सो द पार्लियामेंट हैज़ ओवरराइडिंग पावर्स. जैसे स्टेट लिस्ट में, कॉन्करेंट लिस्ट में एंड सेंट्रल लिस्ट में तो है, तो वो तो करेगा ही. ओके, बट ये स्टेट एंड कॉन्करेंट लिस्ट वाले में भी पार्लियामेंट कर सकता है. देन द गवर्नमेंट ऑफ नेशनल कैपिटल टेरिटरी ऑफ दिल्ली एक्ट lays down the framework for functioning of the Delhi Assembly and the Delhi government. Okay, so this is that particular chronology. Okay, when did Delhi became a union territory, when it was conferred a special case status,